An order of discharge. An order of discharge under the BIA releases the debtor from all provable claims of the creditors on payment of creditors. Discharge orders are passed by the Superior Court in Ontario. Discharge orders are either automatic or conditional. The BIA stipulates that any debt or obligation relating to a student loan will not be released by an order discharge. An excerpt of Section 178 of the BIA states as follows. Section 178, Sub 1. An order of discharge does not release the bankrupt from, Sub G, any debt or obligation in respect of a loan made under the Canada Student Loans Act, the Canada Student Financial Assistance Act, or any enactment of a province that provides for loans or guarantees of loans to students where the date of bankruptcy of the bankrupt occurred. Sub I, before the date on which the bankrupt ceased to be a full or part-time student, as the case may be, under the applicable act or enactment, or Sub II, within 7 years after the date on which the bankrupt ceased to be a full or part-time student, or Sub H, any debt or interest owed in relation to an amount referred to in any of paragraphs A to G. 178 Sub 1.1, at any time after 5 years after a bankrupt who has a debt referred to in paragraph 1 Sub G ceases to be a full or part-time student, as the case may be, under the applicable act or enactment, the court may, on application, order that subsection 1 does not apply to the debt if the court is satisfied that, Sub A, the bankrupt has acted in good faith in connection with the bankrupt's liabilities under the debt, and Sub B, the bankrupt has and will continue to experience financial difficulty to such an extent that the bankrupt will be unable to pay the debt. Therefore, in relation to a debt or obligation relating to a student loan, the factors to be considered are the date of the bankruptcy, the time when the bankrupt ceased to be a full-time, part-time student. Also, the court may consider an application for discharge made by a bankrupt 5 years after ceasing to be a full-time, part-time student if it is demonstrated that the debtor has acted in good faith towards repayment of the loan and the debtor has continued to face financial difficulty so as to be unable to repay the debt. Student loans within bankruptcies are complex, and an individual should not rely on lay advice or information. It is highly advisable to tread cautiously when an individual debtor of a student loan is considering a consumer proposal or a bankruptcy. Trustees can provide information, advice, and options.